Just treat them as two separate cases. This case has got enough going on.
Thank you.
Acceptable to everybody?
Yes, sure. Thank you.
Okay.
Yes, sure.
Okay, Ms. Berman?
Thank you, Your Honor. Good morning. May it please the court, my name is Stacey Berman, here today on behalf of Berkeley Insurance Company, the appellant in this case. If I may, Your Honor, I'd like to reserve 4 minutes of my time.
Fine.
Thank you. As the court is aware, we've got 2 issues here in this merits appeal stemming from 4 different causes of action. You have 2 causes of action disposed of at the dismissal stage on motion to dismiss, and then 2 causes of action disposed of at the summary judgment stage. So I'll just start, if I may, chronologically, and we'll go back to the beginning to the motion to dismiss stage. But we had counts for tortious interference against the bank and for civil conspiracy. Now, the ultimate dismissal was because of allegedly, or the finding was that Berkeley did not state a claim for tortious interference. And the only element of tortious interference at issue in terms of whether Berkeley stated a cause of action is whether Berkeley sufficiently alleged that the bank intentionally and unjustifiably interfered with the contractual relationship between Berkeley and Tempo here. Now, the trial court seemed to think, if you take a look at the order, which is at the record, page 1997, that a non-stranger to a contract, which is exactly what the bank is here, can never be liable for tortious interference. The trial court doesn't cite to any law to the contrary, says Berkeley didn't argue to the contrary, which is in fact not the case.
So you're relying on the allegations of the Second Amendment complaint?
Yes, Your Honor.
Can you sort of direct us specifically what you think your strongest argument
Allegations.
is based on those various allegations that are contained? I think they letter A through U or A through B, there's quite a number of them.
Absolutely, there's a number of them. This is a very, very robust complaint, and I will touch on those and simply tell you that it's far more robust than any case that's been cited to this court where a dismissal has always been reversed in this type of situation. Our allegations include everything from, if you take a look at paragraph 38 of the complaint, it was always the bank's plan to, with illicit motive and through improper means of control over Tempo, unjustifiably withhold as much as they could of the contract sum, despite Tempo's promise that it would pay Berkeley. The complaint goes on to allege that the bank conspired with Besselo to terminate the GC through, quote, any means and methods available through words to the effect that Besselo should do anything it could to default and terminate the contract. There's also an allegation of secret communications with another contractor in anticipation of breaching the contract weeks before the termination. Paragraph 1 of the Second Amendment complaint, Tempo, I apologize. The bank caused Tempo not to pay and to terminate the contract without following the contract terms for non-payment or termination, thus causing a breach of the contract. Another allegation in paragraph 27 of the Second Amendment complaint, there are extensive allegations about the roadblocks being thrown in Berkeley's way, culminating in an allegation at paragraph 38 that it was, quote, always the plan to unjustifiably withhold as much as they could of the contract sum. Paragraph 52, there are more allegations about planning the contract's termination weeks ahead of time, meeting with other contractors, negotiating fees with Besselo. All of those things would be encouraging a breach of contract, which even...
And I've read the complaint through, and
Yes.
I think your characterization of it being, forget the word you used.
Robust.
Is not inapt. Here's my concern, and maybe you can help me with this. And I'll need to tie this to the order as well, that has definitely been touched upon on Brian's briefs on the other side. What I read here seems to me like you have put into a tortious interference and civil conspiracy framework what sounds a lot like piercing the corporate veil. Because as you all point out repeatedly, the bank is a 99.9% owner of the LP. They're the ones that are pulling the strings. But ultimately, Berkeley as the surety and the original contractor knows this going in, right? I mean, they're doing a contract with an LP that is completely controlled by Bank of America, but they are not in a contract, at least as obligees of the surety, but they're not in direct privity with the bank itself. But everything here seems to be saying is, look at all the bad things the bank did while they were acting as the controlling interest of the LP, which is in essence a piercing the corporate veil argument. So help me out here, because my concern is that a good lawyer putting together a complaint, a civil complaint like this, can get around all the pleading requirements of a piercing the corporate veil cause of action, which has its own separate heightened requirements to plead and prove, simply by casting it all as a tortious interference or civil conspiracy claim. Help me out with that.
So in short, Your Honor, it's definitely not piercing the corporate veil. First of all, ultimately, the bank has that level of ownership. It did not from the outset. So, which, you know, we're going back to the beginning when you mentioned what the situation was when you entered into the contract. Second of all, I think the bank would be the first to tell you that it does not consider itself, that this would not be, I don't think the piercing the corporate veil into this particular argument, because I do not think that the bank is making it very clear that it does not think that it is these entities or, you know, controlling these entities. It has done everything to say that it did not control these things, that it did not cause these actions, that it did not pull these strings. Those are Berkeley's allegations, which we think are correct and true, but the bank has disputed those. So I don't think that's the case. And in any event, Your Honor, at the end of the day, they are not a party to the contract, the construction, the contract here. They're not. Now, do they have an interest in it?
This deal is structured so that they're not.
Correct, absolutely. And so do they have a financial interest in it? Yes, they do. Do they have an economic interest that they have a right to some extent to interfere with the contract and protect? Yes, they do.
Well, my concern is that this scenario happens all the time. Single purpose entities get set up for the express purpose of keeping certain players out of contractual privity, but they're still going to be calling the shots. And it's up to everybody that's negotiating the deals to understand who's calling the shots, who's got the money behind it, who's calling the shots, who's directing who, and ultimately, are we satisfied that we've got sufficient privity and sufficient, you know, recourse against the people that we are in privity with, that will go forward with the deal or not. And my concern, like when I'm reading through these, everything that you're talking about is look at the bad things the bank did while it was directing Tempo. But it had that power. I mean, it could do that. That was the deal that got set up, unless we just go right past the LP, put it aside, and go straight to the people that were pulling the strings here, which was the bank.
I don't disagree that there are contracts structured like this all the time, which is why the law allows for someone like the bank to interfere with this type of contract. Typically, right? Going back to tortious interference for a moment, the elements of tortious interference. It's about who can interfere. One of the allegations is, can you interfere with this contract? And everything you've just talked about, an entity like the bank could and would be able to do so typically. Berkeley's not disputing that. But there is a limit to that. You cannot be behind the scenes and pull the strings so hard to a point where your interference with the contract is then resulting in the breach of that contract, for instance. That's what Florida law draws the line.
Argument in response to what your friend on the other side has made. Berkeley alleged in paragraph 79, A through Z, and all the other paragraphs that you rattled off, there's certainly, we all agree, I think, that there's a robust collection of allegations. But fundamentally, Berkeley alleged sufficiently the malice and self-dealing type conduct to take this out of the otherwise generalized privilege. Is that
Correct.
the nut of it?
Yes, that is absolutely the nut of it. And at the end of the day, Your Honor, and to answer your question, Judge Lucas, we are here at a motion to dismiss. So if we're going to talk about who was pulling the strings and who knew what and what was what, that's exactly, by the way, why this would not be dismissed. This was not dismissed due to anything related to piercing the corporate veil, those weren't the arguments at issue. This was simply a, hey, the trial court says you can't state a claim for tortious interference against a non-stranger to a contract. That's not correct under Florida law.
Can I ask you to focus before we use up all your time, on the quasi-contract thing?
Absolutely, Your Honor.
And my first question for you is, your opponent has argued that Berkeley can't recover here because it has a direct remedy on the Tempo contract. And I understand your argument based on Agritrade and it's similar, that that's fine, that the bank isn't a party to that contract. However, I think we still need to confront that Berkeley has a direct legal remedy against Tempo in this legal realm. I think that's a consideration. Could you address that, please?
And so is your concern, trying to get to what your concern would be, Your Honor, is it a concern about double recovery, for instance, or just the fact that Berkeley has
No,
that?
I get that you can, at the pleading stage and up through summary judgment, certainly Berkeley can plead alternate theories that would eventually not be permissible as double recovery. But no, that's not really my question. My question is that Berkeley does have a direct contractual remedy against Tempo. And that's a factor that's considered in some of the analyses of the cases that you all have cited. So we've got this very close contractual relationship. I'm not sure what the argument would be on the rider bringing Berkeley into, bringing Bank of America into the direct contract with Tempo, but there's an argument there. And so really just trying to get to the guts of what I think is the problem on appeal with the equitable claims. You know, it would be easy if there was a direct contract or if Bank of America had just showed up one day after it made the loan and started directing the architect and whatever. But there's such a close relationship, and fundamentally the deal is, you know, Tempo contracts with its GC to build the thing, you guys bond it, and the bank funds it. At the end of the day, the surety's remedy is typically against the owner. And that's what you have here, only I think Berkeley's been very creative and very aggressive in trying to work around that in this situation. But the fact remains that at the outset, your contract is with Tempo, and everything that's gone wrong here should be redressable in that context.
In theory, although, Your Honor, summary judgment is premature because in other litigation, as noted in this record, Tempo has denied that Berkeley's claims are actionable under the contract. Tempo says that this is not a breach of contract action against it. And so arguably, if that were correct, there's no contractual remedy available to Berkeley. In fact, to get to this point, it is not clear, in theory, I mean, Berkeley does think it has a breach of contract claim against Tempo, to be clear, but Tempo says it does not. And if that were the case, then Berkeley would certainly have other avenues. But be that as it may, you can absolutely, just because there's a contract between Tempo and Berkeley, does not mean, Your Honor, that you cannot sue someone else.
Understood.
Right, for unjust enrichment. And so, and I'm not aware of any cases cited in the cases I know of that deal with these issues would be the commercial repairs case, the Variety Children's case, Wilson, FH Passion. I'm not aware of any of those cases that would prevent an unjust enrichment claim in this particular situation simply because there is an express contract that
What
exists.
about the rider? Does that change anything?
How so, Your
The
Honor?
rider that makes the bank an obligee under the bond
Right.
and incorporates the bond to the rider language. So there's an argument that now the bank is a party to the bond because it's an obligee and that contract has been incorporated.
And so you're saying that there would be a breach of contract action against the bank?
Well, at least as a starting point, the bank is now a party, a direct party to the bond because it's an obligee of like status as Tempo.
Right, well, I mean, yes, although the rider was there to protect the bank and to be sure the bank has certainly not made that particular argument, so that would not.
In fact, the declaratory judgment that I think was stipulated to
Correct.
basically disavows that. But just looking at the rider itself, that creates a question. Let me ask you I had two questions for you on this. My other question goes to the direct benefit. As I understand your argument, putting some of the clutter aside on the benefits and not getting down the weeds of agri-trade and the Judge Davis's opinion and who shot John and all of those, reduced to simple terms, even if you put all that to the side, you're arguing that the tax credits and reputational credit was a separate benefit that Berkeley conferred to the bank. Am I right?
You are, although, and I will tell you that, this is an interesting question about the benefits. Yes, I do think it's a separate benefit. I don't think it matters, by the way, though, whether it is or isn't a separate benefit. I think that under Florida law, it does not require a benefit to flow. It can flow through someone else under Florida law, which is one of the points the bank has made. It says that all the benefits that Berkeley conferred on the bank flow through Tempo. That is okay under Florida law. The only cases that say it's not okay are cases involving suing a principal or a shareholder about benefits that a corporation received. But in any event, without a doubt, things like reduction of BACDC's obligations to pay excess development costs, the business reputation issue, the savings of the $40 million to the bank, those are direct, and separate.
And what do we do with the trial court's order that sets forth the testimony? I think it's Bank of America.
It's Nancy Mano saying that the benefits are the
They're
same.
the same.
Right, and I would say, so what, to be frank? It doesn't matter whether the benefits are the same. The trial court found that it matters that they are the same, and therefore that's a problem. The bank says in its answer brief that it's not a same versus different benefit issue anyway, it's a direct versus indirect benefit issue. So there's that. We address the same versus separate issue because the trial court order used the word same. And we have given many instances of different benefits to the extent that anyone believes it matters, whether it's the same or a different benefit. We would suggest to you that this is sort of all semantics because at the end of the day, same, different, kind of lines up with direct versus indirect, and certainly Berkeley agrees that the benefits do need to be direct. So the question is simply, what's a direct benefit? And we would tell you that these are direct benefits. There is no case law to suggest that they are not. And by the way, all this benefits discussion and this aspect of summary judgment only goes to the unjust enrichment claim. Only unjust enrichment requires a benefit conferral, not quantum merit. So at the end of the day, I don't think it matters that the trial court said that, but I think that we have provided plenty of evidence anyway, that there's a different benefit in case that it does matter, and that these benefits are direct. So.
Jumping back to your tortious interference argument, your opponent in their answer brief argues that the limited exception malice, the gone too far exception, must be alleged as an element of the main claim. And they contend that your allegations don't satisfy that. I think we've been through. But just from a pleading standpoint, I was unable to find a case that says that exception must be alleged as part of the main claim.
No, I could not find one either. I do not think there's a case law under this says that.
Very good breaking point for you.
Thank you, Your Honor. I'll reserve that time.
Good morning. My name is Stacy Blaine. I'm here today on behalf of Bank of America and the Bank of America Community Development Corporation, who are the appellees in this first appeal. For convenience, I intend to refer to both of them as the bank unless it becomes important that we distinguish between them. Although Berkeley has maintained throughout this appeal that the construction dispute giving rise to the appeal is terribly complicated, the issues in this appeal are actually quite simple and straightforward. Berkeley sued the bank for tortious interference, civil conspiracy, unjust enrichment, and quantum merit. The trial court applied well-established Florida law to reach an entirely predictable result in this case. Now, I heard for the first time today that Berkeley would agree that it had an obligation to plead unjustified interference with the contract between Berkeley, or the business relationship between Berkeley and Tempo, and that a stranger to the relationship is an element of that pleading requirement. Doesn't take long to read through the complaint to realize that the bank is no stranger to this relationship, even if you look no further than the four corners of the complaint. So now it seems like where the argument has evolved is that we are now left with the exception to the unjustified enrichment, and that is where malice is solely the purpose for the interference, or whether the means that are used are improper. Here what we have are allegations that say that the bank took action to protect its own interests, but it didn't do it using any means that were prohibited to it under the agreement. And in fact, the trial court found these are exactly the sorts of things that lenders do to protect their interests in the collateral. And so clearly there's no allegation, you know, I don't think that my colleague.
Berkeley alleged, plainly and repetitively, that many of the actions the bank took were designed to protect the bank's interest, and were based on ulterior motives and not taken for the benefit of Tempo. That comes through loud and clear in the allegations of the Second Amendment complaint.
But there's nothing wrong with that. I mean, there's absolutely nothing wrong with the bank protecting its financial interest as the lender in the project.
Of course, but doing so based on ulterior motives.
Well, having a bad motive is not enough. It has to be solely through malice, or it has to be an improper means. Here, there's no improper means, and there's no sole motive of malice.
Motive's usually a fact issue, right?
Well, it typically is, but here, I mean, the allegations are all on the face of the complaint. And so I think the court was well within its authority on a motion to dismiss to say, if I accept as true all of the allegations of your complaint, you still haven't alleged what you need to allege.
Well, for example, and I think this is threaded through the complaint, colluding with or controlling the owner in such a way as to prevent Berkeley from being paid. Isn't that improper?
And if it has the power under the contract, as the court says it did, that's not improper. All it's doing is exercising its contractual right.
Of their allegations and your position on them. Your position boils down to the bank was privileged. And that, the cases say, and I don't think there's any discrepancy across the case law that we've studied so far, that is a fact question.
So, I mean, it's an interesting issue. So I think it's a burden shifting issue. I think clearly a plea requirement for Berkeley to prove unjustified interference. And to the extent that it's trying to say we are pleading an exception to the unjustified interference requirement, that's a pleading requirement. And then if they
you don't cite a case for that, and we're not able to find one. So that's based on your pragmatic view of the case law as it stands today.
Well, and the case law says that, you know, an element of the cause of action is unjustified interference, and so that is a pleading requirement.
They've alleged unjustified
Right.
interference without question.
And so then I think, and there is one case that's cited in the brief that talks about then once unjustified interference has been alleged, the burden then shifts to the defendant to say, okay, even though I'm a stranger to the relationship and my interference would not as a matter of law be justified, I'm nonetheless privileged to interfere because I do have some relationship or some ability to protect my own business interests. And an example of this would be in the employment context. So an employer has an employment relationship with the employee. New employer wants to hire some folks. And they hire a headhunter, they run ads in the paper or on the internet, whatever folks do anymore, to hire people. And essentially the way that it works in that case is so long as employer number 2 does not induce the employee to breach a non-compete that the new employer knows about, the employer, new employer, is privileged to solicit that employee. And that is privileged conduct, and you can see it all in the cases, that that's not tortious interference with the original employment relationship, even though the new employer is a stranger to it. So that's where the privilege arises, when you have someone who is not a stranger, who actually is a stranger to the relationship, but the behavior is nonetheless privileged. And so I don't think that the privilege that we're talking about here is an affirmative defense. That's a fact issue. I think it's a pleading issue. And then the question is whether, taking the allegations of the complaint, they have pleaded sufficiently. And again, solely malice, not just, some mixed motive, solely malice, or an improper means. Not again an improper motive, an improper means. Have they engaged in some conduct? Have they induced, someone to breach a contract when they do not have the authority under the contracts themselves to have input in that decision? I want to talk for a minute too, and I guess it's an obvious point of what I was saying, but even if the privilege defense is an affirmative defense, the Florida law is clear that the court was permitted to consider the defense if the facts all appear on the face of the complaint. And so it's really a distinction without a difference here. Talk a moment about the unjust enrichment and the quantum merit claims. We could talk about the direct benefit. It's pretty clear after the Koppel decision of the Florida Supreme Court that Florida law requires a direct benefit. That benefit cannot flow through an intermediary. So to the extent that the use of the word same when the court was talking about the same benefit, essentially the court was focusing on the fact that the improvements to the real property that Berkeley accomplished was the benefit. That is the benefit that they've identified all along, and they've said that Tempo, the bank, everyone involved was benefited by the fact that they made improvements to the real property for which Berkeley was not paid. And so the trial court, I think appropriately, concluded that those benefits flowed through Tempo. Tempo was the owner of the project, notwithstanding Berkeley's half-hearted attempts to say that the bank was actually the owner, and sometimes actual attempts to say the bank was the owner. The bank was not the owner of the property. And so to the extent that the benefits flowed through Tempo to the bank as the lender, to other investors, to shareholders, to officers and directors, to employees, those people are not on the hook for Tempo's contractual obligations.
What about the tax credits?
So the tax credits are interesting. That that was an 11th hour shift in position, and I think the trial court said, look, you can't, in summary judgment.
Sometimes the best stuff comes at you.
Well, I know. It never fails, right? Essentially, the court said you can't change your position now about what the benefit was. I mean, you alleged what the benefit was, your corporate representative testified about what the benefit was, and now to defeat summary judgment, you come up with a new benefit, and that's too late. But even if you did talk about it, those benefits flowed through Tempo too. I mean, the tax credits came about through Tempo, the owner of the project. And so I don't really think that does much to salvage the claim. And, it's interesting, to reach any other conclusion would really be nonsensical. I mean, the law in Florida cannot be that anyone who receives money from a corporation is nonetheless on the hook, for that corporation's contractual benefits simply because it received a dividend or it received a loan repayment.
Yeah, money moves real quick in our system.
It does.
Yeah.
And then I want to talk for a moment about the presence of the express contract And so we filed a notice of supplemental authority yesterday with a new case out of the 3rd DCA that was issued after our briefing. And the court explains agri-trade and essentially makes the argument that the bank has made here. And that is, you do not have to have absolute identity in the parties to the lawsuit and the parties to the contract. So long as the plaintiff has a legal remedy against a party to the contract, that plaintiff cannot seek to recover in quasi-contract from somebody who's not a party to the contract, so long as it's about the same subject matter. I mean, of course, it could be something different. So here is exactly the situation that we have. The court in Nichols, the name of the new case, explains that the existence of a valid legal remedy against one party, which is here Tempo, the breach of contract action against Tempo, will bar a quasi-contract claim against another party, including one who's not a party to the contract, which is here the bank. And so the presence of the express contract gives Berkeley a remedy, it gives Berkeley a legal remedy, and it bars the quasi-contract claim against the bank.
So does that mean that you win on the summary judgment?
I'm sorry?
The summary judgment, in your view, that's the justification for why it was granted?
I think that's right, is that
That's
it's,
the right result.
I do think it's the right result. I think it's the right result, and I mean, particularly in a case like this where the contract includes very specific limitations on Berkeley's ability to recover under the contract. If the court were to permit a quasi-contract action for that same obligation, it would have none of those contractual limitations. And so,
reduced to simple terms, your point on Peoples is it sufficiently distinguishes agri-trade in a way that neutralizes whatever the loose ends were in Berkeley's argument or yours, depending on perspective.
I think that's right.
The explanation, and notwithstanding Judge Booker's concurrence, pretty much ties that up and using her metaphor, puts the bow, or I think your predecessor's metaphor, puts the bow on top of.
I think that's right, and it
something.
right. It clarifies that the only party that has to be a party to the contract is the plaintiff.
And that if there is a legal remedy against the same subject matter, blah, 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 right?
Yes.
Does the new summary judgment statute figure into this?
I'm sorry?
The new summary judgment, does that figure into the calculation?
Well, I don't think so. I don't think that the appellant has challenged the court's application of the new statute. Now, the court revisited its decision. It originally denied summary judgment under the old standard. And after the adoption of the new standard, the bank filed a renewed motion and the court granted it under the new standard. And so I can't say that it had no bearing, but I don't think it has bearing on this appeal because no one challenged the propriety of that decision, or for that reason. I thank you for your attention.
Your Honors, I have just a few points, and I'll sort of work in reverse order. Starting with the, we just talked a minute about the Peoples case and whether that resolves the agri-trade issue. Actually, it does not. Just to put it bluntly, I think the 3rd DCA just has it wrong. Every other DCA in the state of Florida and the Middle District of Florida disagrees with that. It's just a false distinction, this notion that it matters what side of the V in the unjust enrichment claim you're on, in terms of whether you're also a party to the contract. Agri-trade simply says if you're both parties to the contract, you can't have an unjust enrichment claim. You can't have an unjust enrichment claim if you're not both parties. It doesn't talk about who, in the unjust enrichment claim is the plaintiff or the defendant, and whether they're a party to the contract. In multiple cases, allow the plaintiff in a quasi-contract claim to sue where the plaintiff is one of the contracting parties. The Shands case out of the 1st DCA, the Henry and Butler case out of this DCA.
I think the difficulty analytically is that, and this is kind of old form of commercial litigation laws, that once you prove the existence of a contract dealing with a transaction,
the equitable remedy of an unjust enrichment has to go by the wayside because presumably the parties memorialized all the understandings and all the benefits that were going to flow to whom in the instrument.
If they were all parties to that contract.
Right.
Which they're not here. So, and which is why Williams on the 5th DCA, the commercial repair case, Variety Children's out of the 3rd DCA doesn't agree with Peebles, and yet Peebles mentions none of these cases, including its own Variety Children's case, creating, and it looks like a bit of inter-district conflict they've got going on. So the Peebles case is problematic, to put it mildly. Back to direct benefits, the bank says they cannot flow through an intermediary. That is just flat not the case. The LLC case on the 5th DCA specifically says it can flow through an intermediary. We've also got the State Farm case that says that Florida law does not require a direct benefit to flow to a defendant in order to be.
Do any of those cases address the issue where the recipient of the flow-through benefit has a controlling ownership interest of the defendant?
I don't think so, Your Honor. I don't think so. That's the short answer. I don't think so. I think we could talk about that a little more, and then I could get kind of down a rabbit hole with you on what the ownership issues are in this particular case, which all goes part and parcel to why this all needed to be developed a bit more, and why I do not think, again, I think.
You're saying the ownership issue has to be developed more
I think you're asking me too about piercing the corporate veil and tortious interference. And I think, my impression, based on the briefing and all the arguments in the trial court, is the bank would never suggest in a million years that it is acting in a position of ownership whereby there would ever be a situation where the corporate veil.
Loosely, and control.
Okay.
Because an LP is made up of its partners, and the partners have to exercise control.
But I think that matters, because the only benefits cases that allow that don't allow the unjust enrichment claim have that very clear, very precise, not just control, but ownership issue where you've got a shareholder or a principal to a corporation. There are no cases that I'm aware of, and none that I'm aware of cited by the bank, that have what you're talking about and what we're talking about here is Berkeley, this control issue. But, and again, and even if we set that aside, I think anyway, there are separate benefits. I'm just making that point for you. But I do think that we could accept this premise and there would still be what the bank would define as direct benefits. Finally, turning back to tortious interference, the bank just mentioned that the face of the complaint shows there's no allegations of unjustifiable interference. I think the court is aware that that is incorrect. However, even if we just look at those allegations, if a non-stranger like the bank is here encourages breach of contract, which is not something that was just mentioned, but there's case law that says that's one of the things, that's where you can go beyond the limits of your privilege to interfere as a non-stranger. That's just Florida law on that point. There is no doubt that Berkeley has alleged that the bank encouraged breach of contract and then then we have a dismissal of the claim. There is not a single case out there that upholds a dismissal in this type of situation. And this, again, as far as I'm aware, every dismissal case cited to this court is a reversal in a case like this. I have not found any affirmances whatsoever. And finally, Your Honor, I did want to go back because we got away from it and I was a little concerned if you had any more questions related to that piercing of the corporate veil issue, because I do not think it is at all the same thing. I think there's a reason it's not briefed like that in the trial court and it's not briefed like that here. I don't think.
Well, the other side did bring that up. They brought it up in their answer brief.
On the dismissal for the tortious interference?
I can't remember exactly what page or what issue,
Okay.
but I do remember
that it was at least suggested that what's really going on here is or an alter ego.
I thought,
That's basically the same.
and I'm like you, I could be wrong. I thought that was in response to the summary judgment issues on the quasi-contract claims, but perhaps I'm wrong. I did not think that that was raised on the motion to dismiss. I don't think so, and I think that that matters. Because I think we would have fleshed this out quite a bit more, because I do not think this is at all like piercing the corporate veil, and I think we would, have case law and lots of things to talk about. And again, the fact that we're having this big debate, by the way, I think illustrates exactly why this case should not have been dismissed at the stage it was at. It just shouldn't have been. It was premature, and I don't, whether we call it an affirmative defense or not, the privilege to interfere, We've argued that it is. I think it is. I think it doesn't matter. Even if we accept the bank's argument that it's not an affirmative defense, it's still a fact issue that we didn't get resolved. So for all of these reasons, I think this court should reverse and remand on both the order of dismissal and the summary judgment order, and send back down to, have those claims go forward. Are there any other questions I can answer for the court? All right, thank you.
Moving right along to